So you guys often tell me that I find the best cases, but it's not me. It's YouTube autoplay that finds me the weird cases. I was listening to this one last night and wow, the backstory. So this is a case of a gentleman who would like his gun rights restored. He had them taken away as a teenager when he unalived his best friend.
Last October, the teens were playing during a sleepover at a Kelso home when the boy said he accidentally shot Vasquez.
So 13-year-old Dawson Dunn lived on a property in a building on the same property as his grandparents' house. His cousin, EF, was at the grandparents' house whenever her mother had custody of her. So Dawson was having a sleepover with his best friend, Edgar. They were hanging out at the grandparents' house with his cousin, EF. The grandparents were gone, so it was 3, 12, 13-year-olds hanging out at the house. Only people there. They were watching YouTube on the phone, back and forth, whatever. EF notices Dunn goes into his grandparents' bedroom, which is straight off the living room, and he's going through drawers on his grandfather's side of the bed. Next to the bed, there's a chair, and behind that chair, there is a pellet gun and a shotgun leaning up against the wall. Now, the kids have been told never touch the guns. Don't play with them, they're not toys. One of the guns was a camouflage 12-gauge Benelli shotgun with a flashlight taped to the barrel. So EF goes back to her bedroom at the house. Dunn is on FaceTime with his girlfriend, and Edgar is on FaceTime and then not on FaceTime and talking to Dunn. They're kind of around the house doing whatever. They go into EF's bedroom, they're talking to her for a minute, and then they go back out. Now, EF, the cousin, hears Edgar say something about threatening to text the girlfriend. And she hears Dunn say something. Then he says, "Stop chasing me." And over FaceTime, the girlfriend hears them running around and laughing as if they're chasing each other. And then right after this, they hear a gunshot. Then Dawson comes running, screaming into EF's bedroom. He's screaming, "I shot Edgar." He told her to call 911, but when Edgar had left, he had taken EF's phone. So they're trying to find the phone, and the phone is actually on the windowsill next to the bed where the guns were. Yeah. There's a very, very, very complex argument, extensive, lots of tests about where exactly everybody was when this happened. So they call 911. EF starts performing chest compressions on Edgar, trying to save him, but he suffered extreme trauma because it was a bird shot. It went his face and his chest, so he was not breathing. A defibrillator was not successful. So Dawson told the detective there, or the deputy that arrived, that he had pointed the shotgun at Edgar and pulled the trigger. He said he racked the gun and the shell came out. He was surprised that it was loaded, being that it was laying up against the wall. He told them that he racked it again and didn't see anything, so he pointed it at him because, he thought it was unloaded. And then he pulled the trigger. He said that after the pew-pew went off, that Edgar reached for his neck and his chest and fell backwards onto the couch. The deputy asked Dunn if he had ever shot a gun before. He said yes, he was familiar with that gun and had shot that particular gun multiple times. Another deputy went into the bedroom, looked around, and tried to find the live round that he claimed that ejected because he said he racked it, a live round came out. He thought it was unloaded and then he shot. He was not able to find that. He did observe the camouflage shotgun propped up against the wall. On the floor, he saw the spent casing. Another deputy came in, observed the same thing, the camouflage pew-pew against the wall, next to the black pellet gun. He also observed the spent casing on the floor. He checked the pew and noted that the tube was empty. He racked it and a live round ejected. Now, that shouldn't have happened. As time went on and they got to the story changed just a little bit. Dunn testified later that he had gone to the grandfather's room and handled the pew. He testified that he'd been told not to, which, he knew, and he had never touched it before. He claimed that he pulled the lever to make sure it was unloaded. He testified he twirled it around, and while he was playing with it, it discharged. And he had no knowledge of where Edgar was when it discharged, and he didn't pull the trigger. He was just playing with it. It was a total accident. Now, this differs significantly from his story at the scene where he said he pulled the trigger. However, that first story So the only evidence they really had in this case would be the forensic evidence. There was incredibly in-depth calculations done by the birdshot is a lot of pellets that spray around, and it has a spray area where they land. So looking at the injuries that Edgar suffered, looking at the damage to the window and the wall behind where he was, they calculated the trajectory to try and figure out the distance away from Edgar that Dawson and the gun would have been, and also what angle he was holding it at, and everything else. And the prosecution argues that there's no way he was twirling it around, that there was several experts that tried to do that and couldn't make that happen. On the other hand, the defense argues that, yeah, it could, and it did, and that's what happened. The defense's main argument was that Dawson had never seen that particular pew before. He had never touched it, held it, and it took an experienced range master over 10 minutes to familiarize himself with it because it was drastically different than the normal pews. Yet, on the scene, it was a different story. So, somehow, the charges were reduced to second degree, and Dawson ended up serving 5 months as a juvenile for this.
13-year-old Kelso boy who accidentally shot and killed his friend. Here's his sentence: 5 months of juvenile detention and a year of probation. K2 is not naming the teen because he was in juvenile court, but he was found guilty of second-degree manslaughter in the death of Edgar Vasquez.
So after 5 years, which is how long it's been since the incident occurred, 5 years and a couple months, he is technically free and clear of the crime. Like, he is off probation. he has served his sentence, he is done, and can move on with his life. Now he wants his gun rights restored. The prosecution called the victim's family, who is obviously very upset about this and doesn't want this to happen. But legally, he has complied with his penalty for this crime. Interesting world we live in.
242-000-5108, Dawson Dunn petition. I don't know if Mr. Morgan is here. Oh, there you are. Under Maxwell Lee, I should have known.
Yes, Your Honor.
All right, I'll turn it over to the parties on what we're doing today.
Your Honor, Mr. Dunn had filed a petition, I guess through Mr. Morgan a few weeks ago. If Your Honor may recall, we were here 2 weeks ago. I had asked that it be set over approximately 2 weeks for me to reach out to the victims related to this case, which is contemplated in the newer statute. So I was able to make contact with the mother of the deceased kid from this underlying criminal matter. So I have had the opportunity to speak with them.
Okay.
I think Mr. Morgan's petition probably speaks for itself. The state did file a response pertaining to the petition. Obviously, we had received a response from the Washington State Firearm Division, which I think is Exhibit B, indicating they appear to be eligible. Exhibit A, the Washington Healthcare Authority, indicates eligibility, which would basically mean Mr. Dawson's never been ITA'd. I do have some information that the family did want just conveyed pertaining to this petition to restore firearm rights.
Yeah,
And I
please
would
do so.
object to that, Your Honor, if I may. Yeah, this is not, my understanding of reading law, something that's discretionary. If the person is eligible, it's a ministerial act. And even with the new change in the law, they kept the language that allows for a sealing of a juvenile record to be the equivalent of a certificate of rehabilitation, which necessitates restoration. So I understand Mr. Jervikainen's stance here and what he wants to do, but it's totally immaterial as to whether or not my client is eligible.
And what I understand the argument. I am going to allow, I think there's a difference between the criteria that I will use to decide this petition versus a victim's right to be heard, which is contemplated under the new laws. So Mr. Jervikainen, go ahead.
No, Your Honor, just I guess briefly in response to Mr. Morgan, the case that he cites has to do with sex offender registration relief, at which point the current statute has overturned that court ruling. But nonetheless, in talking to the victim's mother, as you can imagine, this was an incident, a very unfortunate incident that involved a 13-year-old killing a 13-year-old. The family obviously does not agree with this petition for restoration. Speaking to the mother, their belief is that Mr. Dunn should be able to live his life without guns. They've had to make alterations in their lives, obviously in losing their son, but nonetheless, I mean, they still obviously, even 6 years later, have a huge void in their life, and they don't believe that Mr. Dunn should get his firearm rights restored. I know they still have a lot of concern and a lot of obviously unknown from this incident. They never really feel like they got an apology, nor exactly any substances of what may have happened in the last seconds of their son's life. But they did want me to convey to the court that they did not believe this petition is appropriate. And so that's what I'm conveying to Your Honor. But in my response, I do point out that Mr. Dunn, he got 5 months from this. It was 30 days plus a 4-month firearm enhancement. So he is approximately 3 or 4 months beyond the 5 years statutory requirement to remain crime-free. So according to the statutory factors, he does appear eligible. And I've conveyed to the court the family's feelings related to this matter, which obviously is very difficult to them. This is the second time we've had to reach out to them. Once, or the first time was last year, February 3rd, about the sealing, and now the restoration of firearm rights. So that's the position's family related to restoration of firearm rights.
I appreciate that. Mr. Morgan, go ahead with any argument you want to make.
Well, our condolences go out to that family. This was never alleged to have been an intentional act. My client lost his best friend. My client's family are sportsmen, outdoorsmen. Pretty much every relative he has, possesses firearms. Regardless of whether or not my client himself goes out to obtain a firearm, which is not necessarily the objective immediately, it's to not have to be in fear of future felony prosecution for simply being around his father, being around his grandfather, residing with them while he gets his education. So this is a situation, Judge, where I think he is eligible. As I mentioned, I believe it's a ministerial act. And we would ask Your Honor to sign the order.
So in my review of this case, NRCW 941047, I do believe that it is appropriate to sign the order restoring the petitioner's firearms rights. I'll just say that I want, if the victims are watching this, I think that number one, I also give them my condolences. I understand their position. I appreciate them taking the time to essentially relive this, to give their input. I think it is appropriate for this court to take into account and hear from victims, but ultimately, the language of the statute requires me to sign this order if certain conditions are met. And as indicated by the prosecution, I believe that the petitioner has met his burden of proving that those conditions are met. I have signed the order and I will give it to the clerk.
Thank you, Your Honor. That was our only matter before you, Your Honor.
Okay, thank you, Mr. Morgan.
He will forever be 13 in my visions of him, and he will never get to grow up. I will never have the joy of watching him continue to grow into a wonderful young man and have his own family. Edgar's death has left a huge hole in the heart of my family.
She also called on the 13-year-old boy to be honest about what happened that day. She felt he wasn't truthful in a statement during a hearing.